Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 28th February 2025 and we bring you news that matters. The first news for today is as follows. In a significant legal development, the Supreme Court of India has ruled that high courts should refrain from staying discharge orders issued by trial courts in criminal cases, except under exceptional circumstances. The bench comprising Justice Abhay S. Oka and Justice Ujjal Bhuyan emphasized that even when appellate courts consider appeals against acquittals under Section 390 of the Criminal Procedure Code, CRPC, granting bail should be the norm. This ruling came in response to a plea by Sikh leader Sudarshan Singh Wazir challenging a Delhi High Court order that had stayed his discharge in the 2021 murder case of former National Conference MLC Trilochan Singh Wazir. The High Court had not only stayed the trial court's discharge order but also directed Sudarshan Singh Wazir to surrender, a move the Supreme Court found unprecedented and concerning. Justice Oka questioned the High Court's approach, stating, "How can an order of discharge be stayed? It is completely unheard of. Absolute shocking affairs." The Supreme Court subsequently stayed the High Court's order requiring Wazir to surrender and halted the trial proceedings adjourned him. The case traces back to September 2021, when Trilochan Singh Wazir was murdered. Sudarshan Singh Wazir, a former president of the Jammu Kashmir State Gurdwara Parbandhak Board, was arrested in connection with the case in February 2023. However, in October 2023, a trial court discharged him and two other suspects, framing charges only against one accused, Harmeet Singh. The prosecution's subsequent revision petition led to the Delhi High Court's controversial stay, which has now been addressed by the Supreme Court. This ruling underscores the Supreme Court's stance that staying discharge orders should be an exception rather than a norm, ensuring that accused individuals are not unduly deprived of their liberty during ongoing legal proceedings. Next news. In a significant directive, the Supreme Court of India has mandated that all states address critical concerns regarding the procurement and quality of antiretroviral therapy ART drugs for individuals living with HIV/AIDS. This order stems from a public interest litigation, PIL, filed by the Network of People Living with HIV/AIDS, highlighting systemic issues in the ART drug supply chain. The bench, comprising Justices Abhay Oka and Ujjal Bhuyan, instructed the states to submit detailed affidavits within 1 month, specifically responding to 6 key issues outlined by the petitioners. These issues encompass periodic stockouts, transparency in tendering and procurement, and the quality and certification processes of our drugs. The court emphasized the necessity for states to particularly focus on the third issue, which pertains to drug quality and certification. This judicial intervention aims to rectify recurring shortages and ensure the uninterrupted availability of high-quality ART medications, thereby safeguarding the health and rights of people living with HIV/AIDS across the nation. Next news. In a landmark ruling, The Supreme Court of India has upheld the constitutional validity of Sections 69 and 70 of the Goods and Services Tax (GST) Act, which empower authorities to arrest and summon individuals suspected of tax evasion. The bench, led by Chief Justice Sanjeev Khanna and comprising Justices M. Sundaresh and Bela M. Trivedi, affirmed that these provisions are essential for the effective enforcement of GST laws and are within the legislative competence of Parliament under Article 246 of the Constitution. The court emphasized that the power to arrest and summon is incidental to the authority to levy and collect taxes, rejecting arguments that such powers were beyond Parliament's legislative scope. However, the bench underscored the necessity for procedural safeguards to prevent arbitrary use of these powers. It mandated that arrests under the GST Act should not be routine and must be based on credible material evidence. Additionally, individuals arrested under these provisions are entitled to the same rights as those arrested under standard criminal law, including being informed of the grounds of arrest and the right to legal representation. This ruling aims to balance the government's need to curb tax evasion with the protection of individual rights, ensuring that enforcement actions under the GST framework are conducted with transparency and accountability. Next news. In a significant ruling on February 27, 2025, the Supreme Court of India clarified that under Section 14 of the Partnership Act, 1932, any property contributed by a partner becomes the property of the partnership firm. Consequently, neither the contributing partner nor their legal heirs retain exclusive rights over such property upon the partner's death or retirement. Their entitlement is limited to a share in the firm's profits proportional to their contribution. The bench, comprising Justices Sudhanshu Dhulia and Asanuddin Aminullah, addressed a case where the legal heirs of a deceased partner claimed ownership of a hotel property that had been integrated into the partnership assets. The appellants argued that the property originally acquired by their father should not have been transferred to the partnership firm, and contested validity of its transfer via a relinquishment deed. Upholding the decisions of the trial court and the High Court, the Supreme Court emphasized that formal documentation is not mandatory for transferring property to a partnership. The act of contribution itself effectuates the transfer. The court noted that constructing the hotel on the land contributed by the deceased partner evidenced his intention to make it a firm asset. Thus, the property in question was deemed to belong to the partnership firm, and the legal heirs' claim to exclusive ownership was dismissed. This judgment reinforces the principle that contributions made by partners to a firm become collective assets, and individual claims by legal heirs over such properties are not maintainable. Next news. In a landmark decision on February 28, 2025, the Supreme Court of India overturned the termination of two female judicial officers from deeming the dismissals punitive, arbitrary, and illegal. The bench, comprising Justices B.V. Nagaratna and N.K. Singh, ordered the reinstatement of the officers within 15 days, restoring their seniority and ensuring their probation was confirmed retroactively to align with their peers. Justice Nagaratna's judgment highlighted the necessity for sensitivity towards the unique challenges faced by women in the judiciary. The court emphasized that personal hardships, such as health issues and family crises, must be considered when evaluating performance. Justice Nagaratna noted we need to be aware of the anxieties and difficulties which women face. This ruling underscores the importance of creating a supportive environment for female judicial officers, acknowledging their physical and psychological challenges, and ensuring fair treatment in their professional assessments. Next news. In a recent judgment, the Delhi High Court dismissed a petition filed by the daughter of the late Maharaja Dr. Karni Singh, the last Maharaja of Bian, seeking arrears or rent from the central government for the Bian House property in New Delhi. Justice Sachin Datta ruled that the petitioner failed to establish any legal right over the property or entitlement to the alleged arrears. Historically, after the integration of princely states into the Indian Dominion, Bian House was leased by the central government from the Rajasthan government and Maharaja Karni Singh in 1950. The arrangement stipulated that 67% of the rent was payable to the Rajasthan government and 33% to Maharaja Karni Singh. Payments continued regularly until 1991, the year of the Maharaja's demise. Post 1991, the petitioner requested the release or rent in 4 equal installments to the legal heirs. However, the central government ceased payments, citing the need for a no objection certificate (NOC) from the Rajasthan government. In 2014, following a Supreme Court directive, the centre vacated Bian House, handing over the property to Rajasthan government officials. Despite this, arrears from October 1991 to December 2014 remained unpaid, and the NOC was not issued. The court emphasized that the Rajasthan government holds full and absolute rights over Bian House. It further noted that the petitioner's claim was based on a 1951 letter indicating that the centre agreed to grant 1/3 of the rent to the Maharaja's estate on an ex gratia basis, implying a moral rather than a legal obligation. This ruling underscores the importance of establishing clear legal rights when claiming entitlements, especially concerning properties with historical and governmental significance. Next news. In a recent ruling, the Allahabad High Court denied bail to Dr. Shenawaz, accused of raping a 20-year-old Dalit nurse during her night shift at a private hospital in August 2024. Justice Nalin Kumar Srivastav emphasized the gravity of the allegations against Dr. Shenawaz, noting his central role in the purported crime. Conversely, co-accused Mehnaz, a nurse, and Junaid, a ward boy alleged to have assisted in the offense, were granted bail, with the court considering factors such as the nature, evidence, and their specific involvement. The prosecution asserts that Dr. Shenawaz summoned the victim to his cabin around midnight. Upon her refusal, she was forcibly taken by the co-accused, after which the doctor allegedly committed the assault. The defense contended that the accused were falsely implicated, citing discrepancies in call detail records and CCTV footage. However, the court found sufficient grounds to deny bail to the principal accused while granting relief to the co-accused. Next news. In a significant ruling, the Na High Court has set aside an order that withheld the entire pension and gratuity of a 73-year-old retired superintendent from the Commissioner of Central Excise, Customs, and Service Tax. Justice M. Nagaprasanna emphasized that imposing a penalty of withholding 100% or pension and gratuity lacks legal sanction directing the authorities to release the withheld amounts within 4 weeks. The petitioner, Hanumant N. Karkun, faced allegations in 2011 of demanding a bribe for issuing a service tax registration certificate. Following an investigation and subsequent retirement in 2012, a disciplinary inquiry mirrored the criminal charges. Despite his acquittal in the criminal case, the disciplinary authority imposed the severe penalty in February 2023. The court found this action impermissible under the Central Civil Services Pension Rules 1972 and the Central Civil Services Conduct Rules 1964, especially given the acquittal and the petitioner's health condition. This judgment underscores the necessity for disciplinary authorities to adhere to legal provisions when determining penalties, ensuring that actions are justified and proportionate. Next news. In a significant ruling, the Aurangabad bench of the Bombay High Court has clarified that under the Hindu Minority and Guardianship Act, 1956, a natural guardian who is also the eldest member of a Hindu joint family can manage joint family properties including the undivided interests of minor members without prior court permission. This authority is contingent upon ensuring that any actions taken are in the legal necessity and best interests of the minors involved. Justice Santosh Chapalgaonkar presided over the case, which involved petitioner Pooja Popalghat seeking to sell a land parcel in Beed district. The property, initially registered under her late husband's name, was jointly mutated to include Pooja and her 3 minor children following his demise. Residing in Pune and employed in the private sector, Pooja intended to sell the land to fund her children's education and cover family expenses. Her initial application to the district court in Beed was denied on the 1st of December 2023 on the grounds that there were no outstanding educational fees for the children at that time. Upon appeal, Justice Chapalgaonkar referred to sections 6, 8, 9, and 12 of the Hindu Minority and Guardianship Act. He emphasized that while Section 8 imposes restrictions on a guardian's ability to transfer a minor's immovable property without court consent, these restrictions do not extend to a minor's undivided interest in joint family property. Thus, the natural guardian, as the family's senior member managing the property, possesses the authority to make decisions regarding such assets provided they serve the minor's welfare and are necessitated by legal obligations. This judgment underscores the legal recognition of a natural guardian's role in managing joint family properties, balancing the need for familial autonomy with the protection of minors' interests. Next news. In a recent ruling, the Delhi High Court addressed the confidentiality of the Central Bureau of Investigation (CBI) Final Report Part IFRI. Justice Anup Kumar Mendirata observed that while the FII is primarily an internal document intended to inform supervisory officers and legal advisors within the CBI, its production before a court at the cognizance stage cannot be denied if exceptional circumstances are demonstrated. This decision emphasizes the balance between maintaining investigative confidentiality and ensuring judicial transparency when warranted. And the final news for today is as follows. In a recent judgment, the Delhi High Court annulled the Indian Olympics Association's (IOA) decision to appoint a 5-member ad hoc committee to oversee the affairs of the Bihar Olympics Association (BOA). Justice Sachin Datta ruled that the UA president lacked the authority to constitute such a committee unilaterally, emphasizing that any action to suspend or replace a state Olympics Association AS executive body must be undertaken by the EO's General Assembly, as stipulated in Article 6.1.5 of the IOA Constitution. The court directed the BOA to amend its constitution to align with the IOA Constitution and the National Sports Development Code of India 2011. It mandated that elections for the BOA's executive committee be conducted within 3 months. Failure to comply would permit the IOA to initiate disciplinary actions, including suspension, against the BOA. This ruling underscores the necessity for adherence to established constitutional procedures within sports governing bodies, ensuring that decisions impacting state associations are made collectively by the appropriate authorities. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.